This is the Buried in Work podcast, where we share tips and interview experts to help you simplify estate planning and end-of-life tasks.
I'm your host, Adam Zuckerman, and today we have a very special guest, Jonathan Steele. Jonathan is a family law attorney specializing in high-stakes divorces and the founder of Steele Fortress, which is a cybersecurity and privacy business. His extensive experience in family law includes handling complex cases, including marriage dissolution, child custody, and business interests. His unique expertise in cybersecurity allows him to protect his clients' digital privacy and security during vulnerable times such as divorce and custody battles. Today, we're going to have a great conversation with him, and we'll see where things go. But with that, Jonathan, it's great to have you here.
Adam, thanks for having me. That was quite the intro, so I appreciate that.
Hey, you can hire me to do your PR. Let's start a little while ago. So talk about your journey into family law and what inspired you to also specialize in cybersecurity, because those are two fields that are oftentimes not linked directly.
I think they're pretty far apart, actually. I started as a law clerk when I was in high school, and I clerked for a divorce lawyer in Chicago and clerked for him all throughout high school. Child labor laws be damned. And then I continued on through college during the summers and all throughout law school, and then just sort of fell into divorce law because I rode along with him. Recently is when I've gotten into the cybersecurity and privacy space. I've always sort of been a privacy geek. I've liked the, apps, Signal, Proton Mail, things like that are a little more privacy friendly. And given the slowdown, I would say, of work, or at least court work during COVID, I had some free time until courts pivoted and figured out how to get on Zoom. And rather than using that time to watch Tiger King and learn how to bake bread, I used it to go down a deep, dark rabbit hole that I've yet to find the bottom of, where I've watched all sorts of YouTube recordings and podcasts, and I did a fair amount of reading about the subjects of security and privacy in general. And then I sort of did more formal education, got some certification for cybersecurity, and now it's related to my practice. There's definitely overlap because people come in at the infancy stage of a divorce and they're pretty convinced that, right or wrong, that their spouse has access to their data, to their devices, and they look to me to be able to guide them on unplugging that access, buttoning up their privacy settings on their social media, ensuring that their devices are free of spyware, and just generally giving them the ability to sleep at night knowing their spouse is not reading all their messages, reading their emails, being able to access their photos and things like that.
Typically, where in the process does that come into play? Most people don't realize that securing your information during a divorce proceeding is extremely important. When do they come to you, and how do you actually go through that process?
It usually comes out when it's too late. The other side will start building their case very early on, and they'll be mounting evidence by way of all of your social media posts. And you'll find out when they have to tender their discovery or their exhibits for trial, and then it's too late to do anything about it. And, there are times when, you're fighting over custody or parenting time, and you see that while you had parenting time, you were out at bars, and they know that because you were posting pictures and you were, basically time stamping them. Or you'll be somebody that's a maintenance candidate or alimony candidate. You'll be seeking maintenance at trial, and the other side will come out with pictures showing you dating during the divorce or vacationing during the divorce with a boyfriend. And that's pretty damning evidence that you're cohabitating during the case, and you may lose your right to maintenance because of that. So people don't really know, and it's a hard sell as a lawyer to convince a client either get off of social media while your case is pending, or at least try to prune your followers and friend list so that you can ensure that the people that are following you and that have access to your account aren't feeding that information to your spouse.
So the process plays out. Divorce is in the works. It's finally finalized. How does divorce impact someone's estate plan, and what immediate steps should someone take to update their documents during or after a divorce?
Yeah, it changes everything for the most part. There are certain steps you can't do during a divorce. You can't change a whole lot of trusts. You can't change a whole lot of wills. You can do certain modifications to certain forms of life insurance. And pretty much anything major that you're trying to do during the divorce, you can be assured is going to result in a motion being filed asking you to undo what you've tried to change. But sometimes your spouse will try to run the clock on you depending on how old you are. I've had some elderly clients where they drag the divorce so that they can inherit from the estate as opposed to getting what they would be entitled to under the divorce. And, whether or not you have a prenup coming into your marriage plays a heavy role in what the estate entitlement is, whether or not you've waived your right to renounce your will. All of that plays into the divorce case pretty heavily. Post-divorce, it matters a little bit less, but it definitely plays into how the divorce shakes out.
So let's say that the divorce goes through. Talk about some of the specific changes that people do need to make to their wills or trusts. What are those considerations?
Once you're divorced?
Mm-hmm.
Well, it depends what your will and trust said going into your divorce. If you had your spouse inheriting from you, certainly you're going to want to change that once you're divorced. And the same is true for your trusts. Sometimes your divorce decree may spell out certain entitlements to your trust, and then you won't be able to change them, or certain kinds of trusts, like a child support trust, may end up getting established during the divorce case to fund child support obligations. But for the most part, unless your divorce decree tells you what to do with your will and your trust, you're pretty much free to do with it whatever you want, which is going to entail changing the beneficiaries to someone other than your spouse.
Let's talk about the beneficiary designations a little bit. Why are those important?
Well, during the divorce case, certainly, if you were to die before your divorce is finalized, you're still married. And so whatever you had in your will or your trust is going to be effectuated as though you weren't in the middle of a divorce case. And then if you get divorced and you don't change your beneficiaries, maybe you slept on it, maybe you didn't think of doing it, your ex-wife or your ex-husband may continue to inherit as set forth in your trust had you not changed it.
All right, so switching over a little bit, you have a will, minors are involved, children. How can divorce influence the decisions regarding guardianship of minor children or dependents after divorce? So what needs to be considered in that circumstance?
Well, your divorce decree or your allocation judgment is going to spell out basically who has decision-making, who has parenting time. It's going to spell out all your rights and obligations related to the child. And then, that's going to be your operative document. That's going to be what you have to butt up against if there is a guardianship proceeding or somebody wants to take custody other than one of the parents. They're going to have to overcome the allocation judgment. But that's the document that's going to lay out who has rights to the child and decision-making for the child. And obviously under U.S. Supreme Court precedent, the parents have that fundamental interest in the raising of their child and the decision-making for their child. So for anybody else to come in and try to usurp that, they've got a pretty high burden.
Okay. There's obviously a lot that goes into a court's judgment as they review individual cases. What role does estate planning play in the process as it relates to division of assets? Can it make things simpler? Can it complicate things? What should people know?
One of the carve-outs for whether or not property ends up being marital or non-marital can be whether or not you did something solely for estate planning purposes. And what I mean by that is if you have non-marital property and you designate your spouse as a beneficiary, the spouse may claim during the divorce case that that's marital property, that you made a gift to the marriage by virtue of your voluntary act of designating your spouse as a beneficiary. The counter to that argument is if you can establish that you did it solely for estate planning purposes, you will retain that interest as your non-marital property. So in that situation, it becomes pretty important, basically your intent, whether you had a donative intent, whether or not you intended to make a gift to the marriage, or whether or not you were doing it for, as I mentioned, estate planning purposes. So it certainly plays into account there. And then various life insurance policies, whether or not they're revocable or irrevocable. Some can be changed during the divorce case. Some can't be changed during the divorce case. So there's a number of nuances there. But I'd say that the most prevalent impact that it's going to have is on that marital versus non-marital designation.
What about inherited property? So does that have a special classification or treatment?
Yeah, so the general rule that you operate under is that property that's acquired during the marriage it carries the presumption of being marital property. You can rebut that presumption presumption a number of different ways, one of which is, as I mentioned, showing that you did it for estate planning purposes, one of which is acquisition to funds that you had before you got married. And so inherited property, even if it's acquired during the marriage, is that another one of those buckets of yes, but. So while you did acquire the interest during the marriage and you're butt up against that presumption of marital property, if you can show that it was inheritance, it's your non-marital property.
What about for blended families? So are there special considerations as it relates to estate planning for individuals who remarry after divorce?
You have no financial obligations towards a child that's not yours, unless you choose to adopt the child. And so it's mostly separated. There are certain circumstances where if the new spouse is lessening the load of the parent from the prior relationship, the extent of them lessening the load or the extent of their financial contributions can be taken into account for setting support for the other child. But for the most part, it is pretty separate. But the circumstances where you have blended families, a prenuptial agreement is a good way of keeping a separation in a clean and orderly way.
Okay. At the beginning of the conversation, we talked about your expertise locking down digital assets and people's digital persona. If you have advice for people before they were to enter a divorce, just general knowledge, even if they are in a happy marriage where nothing is on the horizon, how should they be considering their digital assets and their digital legacy?
It's too late usually when it comes to your attention that something needs to change. And people usually decide after they've been hacked or after their information has been leaked or, they've been the victim of a data breach. And at that point, it's too late. At that point, your information's out there. It's sort of like when you post a picture to the internet, you can pretty much assume you can't get it back. And so buttoning that up, securing yourself in advance is about as good of advice as you can be given. And there's a number of different ways to do it depending on what your digital footprint is going into it. If you are one of these people that have an Instagram page and a Facebook and a LinkedIn and every social media imaginable, there are certain things you can do as far as like your privacy settings and making sure that your account is private and that you're actually keeping track of who your followers are, and then just hardening your device settings, your location settings on your phone, and keeping tabs on that. It's good cyber hygiene to do even in a happily married situation. And if you maintain those same privacy practices and security practices going into a divorce, you're definitely in a better position as the case plays out.
Okay. For someone that's going through a family law issue for the first time, what tips can you offer them to help them navigate the legal system and advocate for themselves effectively?
There's a few. One is to figure out, work it out with your attorney what their best or their preferred method of communication is, because that's pivotal. Being able to communicate with your attorney effectively is very important. And if you're missing each other because you're just communicating in different ways, maybe you're sending 3-4 page emails and your lawyer is old school and they prefer phone calls or in-person conferences, you're just not communicating effectively. And so some attention needs to be paid to that so that you're on the same page, so to speak, as far as how you're communicating. I think it's also important to how you choose your attorney. A lot of people choose cost first, experience second, and that's not always the best approach. Sometimes people get scared off with some sticker shock. This lawyer's charging me $400 an hour, and I just met with someone that's charging $200 an hour, better off with the $200 an hour. And, what they don't take into account there is that maybe the $200 an hour lawyer takes 2 times as long to do the same work, or maybe that $200 an hour lawyer messes up something that you then go to the $400 an hour lawyer to clean up, and then you're paying twice. So, to the extent possible, hire the best lawyer you can afford. It's going to make the process easier. And then I think anything you can do to expedite the process, such as, just organizing the documents that are going to be required of you in the process. You're for sure going to need your last couple of years tax returns, probably your last couple of years bank statements, credit card statements, things like that. And if you can compile those and organize them and send them to your attorney in a way that A, is secure, I'm going to stress that part given my focus on cybersecurity, but also just doing it in a way that's proactive, because you're going to get hit with discovery requests. And then, if you're giving it in dribs and drabs, then you're fighting over discovery and the costs is just going up and up. And so if you can just front that issue knowing it's coming, you're going to streamline the process, make it much less expensive.
What are some of the considerations that listeners might not be familiar with between low value estate divorces and some of the specialties that you focus on with high net worth families?
There's similar issues, but different stakes. The tasks for a lawyer are the same. You have to identify the assets, you have to value the assets, and then you have to distribute the assets. Some of the higher stakes situations, the valuation of the assets can become more complicated. If you have closely held corporations or claims of non-marital property or non-marital components of a business, that can complicate the valuation. If you have someone that's running their own business and they're trying to keep money in the business and artificially lower their income for divorce planning purposes, that can complicate matters. And, issues like that, issues surrounding non-marital tracing, those primarily find their way into the higher stakes divorces, whereas I don't want to call them lesser stakes, but just the more straightforward divorces where you have two W-2 wage earners and a couple retirement accounts and bank accounts to divide, those generally tend to just be easier. They tend to be faster and less expensive to make their way through.
What is non-marital tracing?
Yeah. So for instance, if you were to come into your marriage prior to your marriage, you owned a home, and during your marriage, you sold that home and you bought a new home. As I mentioned earlier, you're going to be butting up against the presumption that that new home is marital property because you acquired it during the marriage. But if you can trace the down payment, if you can trace the funds to a prior home or money that you had prior to your marriage, that second home is still your non-marital property. And so you have to be able to trace it from start to finish. You have to do that by clear and convincing evidence. And just saying that was from my prior home oftentimes isn't going to be enough. You need to show the closing statements. You need to show the wire transfer from one to the acquisition of the new asset. And that. Generally speaking, that's how the tracing works. You're trying to show, yes, I acquired this during the marriage, but I'm tracing it to either an asset or, well, I guess both, whether it's money or property that I had prior to our marriage.
It almost sounds like there's a fair amount of similarity between the roles of a estate executor or administrator and the divorce attorney, in a way, that they need to marshal all of the assets, understand the liabilities, and then distribute the assets properly. Do you think that there are parallels there that are somewhat surprising for a lot of people?
It almost seems like the administrator is more in the role of the judge there, because that's sort of the judge's task too, is to compile a balance sheet with the assistance of the attorneys, obviously, but then distribute them either in the case of a divorce according to statute or in the case of a will or trust according to the terms of the will or trust. So there certainly is a similarity there.
All right. Well, there's certainly a lot to unpack. Jonathan, final takeaways. What do you hope listeners will walk away from your insights on family law, digital privacy, cybersecurity, estate planning today?
Now is the time. As I mentioned earlier, once you have been hacked, once you've been leaked, once you're on the eve of trial in your divorce case and your exhibits are being tendered, it's too late to try to undo the harm. And so you really just need to be mindful of what you're sharing, whether that's photos that may have metadata attached to them, whether that's posts about your spouse or your kids. Just try to be mindful of your digital footprint because it's very hard to get it back once it's out there.
All right, Jonathan, thank you so much. If people want to get a hold of you or reach out for a conversation, where can they find you?
I have a website, steelefamlaw.com. It has all my contact information, all my social media information, and you can reach me there.
All right, Jonathan, thank you so much for your time. We enjoyed the conversation. That wraps up another Buried in Work podcast episode where we feature tips and stories from industry professionals who specialize in making estate planning, end-of-life tasks, and estate transitions more manageable. If you enjoyed the podcast, consider leaving a review, follow us on social media, or go to the website. And don't forget, podcast listeners can save 10% off our estate preparation package and our games with the code BIW podcast. Jonathan, thanks again. It has been an absolute pleasure.
Thank you.
Thanks for listening to another episode of the Buried in Work podcast. Remember, you can save 10% on our estate preparation package and games with code podcast10 at buriedinwork.com.